let's get into the advisory and talk about the recent regulatory and legal developments affecting superannuation trustees, SMSF advice standards and enforcement actions by ASIC and APRA. Jonathan Steffanoni from Legal and Prudential joining me on the desk. Good to see you, Jonathan.
Good morning, great to see you, Julia.
So we've seen ASIC really sort of clamp down on a lot of these SMSFs, suggesting that some Australians' retirements could be at risk. What do you think of the report and what do you think people should be doing?
So ASIC did release their report off the back of a review which they completed into personal financial advice where the establishment of a self-managed super fund was recommended. They looked at 100 client files and found that of the 100 reviewed, only 38 were compliant with the relevant legal obligations and have outlined general concerns that they have off the back of the review in relation to advice which is provided to establish a self-managed superannuation fund.
But in your view, what does all this mean? Does it mean that people should just stick with industry super or they should just be more careful? What are you advising?
Well, the ASIC report focuses in on the fact that the notion of control is often relied upon as being a basis for recommending establishing a self-managed super fund. ASIC has stated in the report that an assumption that an individual will benefit from this notion of control can't always be made. They identified significant deficiencies in the extent to which advisors were exploring with the individual client whether it was appropriate for them or not. So they weren't going to enough lengths to understand whether that amount of control was appropriate for the individual.
So in your opinion, if you want to be in an SMSF, does it just require a lot more due diligence, talking to an advisor, or you just stick with an industry super fund?
The important part of a self-managed superannuation fund is the self-managed bit, and it can't be avoided. ASIC's report goes to effort to highlight this as well, is that it's critical that individuals being advised are aware that they will be responsible as trustee and can't outsource their responsibilities to the advisor and other parties if they're setting up a self-managed superannuation fund.
All right, well, let's move on then to Cbus. So it's been ordered to pay this penalty. What happened here?
So ASIC commenced these proceedings against the trustee of Cbus several months ago. The claims relate to delays which Cbus members experienced in the processing of death and disability claims. So ASIC's case argued that the trustee had failed to satisfy its obligation to provide financial services efficiently, honestly and fairly, which is the go-to legal requirement that ASIC seems to reach for in many of their proceedings. What was interesting about the decision of the Federal Court is that both ASIC and the trustee agreed to the underlying facts, agreed to the contraventions and agreed to the penalties which were imposed. So there are benefits in terms of not fighting every point of the allegations to the death in the efficiency of the hearing and the associated costs. But it is an interesting way of resolving what are quite serious issues. Some of the allegations that ASIC have made are quite serious against the trustee, not only in failing to ensure that the systems and processes were in place to ensure that claims were being processed efficiently. They also imposed penalties in relation to failure to report the breaches of that efficiently, honestly, fairly obligation.
So that's what ASIC's been up to. What's APRA been up to, this licence condition on ethical retail superannuation?
Yeah, so this is more recent. It was late last week. The announcement was made that APRA had imposed additional licence conditions and had issued infringement notices against the trustee of Australian Ethical Super. Now, the announcement from APRA makes reference to the best financial interests duty, but if we do have a look at the nature of the concerns which were raised, it relates to expenditure management. So it's a related but differently constituted obligation which falls on superannuation trustees to manage expenditure in a prescribed manner. The concern related to investment management fees which are being paid to the parent company of the superannuation fund trustee. The concern is essentially that the business case or the decision making before entering into those arrangements hasn't been tested against the market, and that the fees may have been more expensive than what may have been able to be negotiated in a tender or other market-based process.